All right, so there has been an uptick in requests for evidence and notices of intent to deny based on the ability to pay issue for 245I cases. So, if you have a labor certification that was filed by your employer back in early 2000 or the late 90s, maybe that labor certification was approved, but later on, the visa petition filed by your employer was denied because they couldn't show the ability to pay the wages. What we've seen in the last few months is that USCIS is taking the position that if an I-140 visa petition was later denied, then that makes the underlying labor certification case ineligible for 245I protection. Now, this is completely wrong. It's an issue that's been well settled for well over a decade, maybe even two, but it's something that the officers seem to have latched onto, and they're trying to argue that you're no longer 245I eligible. So without getting into the meat of this argument, just know that if you received a decision like that, it is possible to do a motion to reconsider, which is similar to an appeal. We can reach out to the supervisor and point out that their officers are making incorrect decisions, and we can likely get your case reopened. We've done it on a few cases that have come in the door with this issue, and we've been successful. About a week ago, I went to an interview where this was an issue in the case, and so we briefed it and we laid out the entire law on the subject, and the officer said, well, I'm going to need to check on that myself. Okay, check on it, but this is well settled law, so now we're going to be reaching out to their supervisor this week and saying, hey, can you step in here and get this case approved, because this is ridiculous and there should not be any more delays on this. So hopefully you're not dealing with that issue, but if you are, just know that it's not something that you should just roll over and say, okay, well, I guess I'm getting denied on this. There are ways to fight back on this ability to pay issue. Take care.